Thanks for stopping by and checking out my videos. And if you want to learn more about my book, Love Like Snow in Florida on a Hot Summer's Day, go down to the description. I have the links to both my website and Amazon and Kindle Unlimited, where you can read it for free. Hey everybody, this is Tracy here with another edition of A View from Tracy's Point. And we are here with part 3 of the shenanigans that is taking place in the Eastern District of New York. And if you have checked out part 1, we talked about the expert witnesses that the government is planning to bring in on this case. And I will post the link above. And then in part 2, I went over this 55-page motion in Limine that the prosecution is basically trying to bring in bad act witnesses. And basically bad act witnesses is people who are not a part of the indictment. They have no charges pending between them and R. Kelly. These are people that have come forward with stories about their relationship with him. Basically what they're going to try to do is rehash surviving R. Kelly in the courtroom. And then there were some people that we ain't know nothing about. There's 2 young men that they're trying to bring in as bad act witnesses who I guess had a relation. They're alleging had a relationship that turned into a friendship, and then they were like helping out, they part of the enterprise too, y'all. And so they went up to like 20 Jane Does in that document that they submitted, where they're trying to bring all these people in. And as I, stated that, with the Bill Cosby case, where they were allowed to bring in 5 bad act witnesses, they basically had a whole bunch of other women that they wanted to bring in, but the judge ruled that they could only bring in 5 people, and the prosecution had to determine out of the people that wanted to get up there and say whatever they had to say, that they could only bring in 5. So they had to, tread lightly and bring the best 5 people that they have. And so I'll post the link above. It is a long video because I basically brought the information to you. You guys know that, my motto is I'm going to read the indictment. So I might as well record myself reading the indictment and bring it to those of you who don't have access to the indictments or who don't want to read it for yourself. And so that's what I'm doing here. If you're new to my channel and like, Lord, what is this woman talking about for an hour, 2 hours, however long the video ends up being, I'm basically reading the actual court documents and giving my little short, quirky opinions on what I think about, what they have shared with us. And so you can go ahead and check that out. Part 1 is a very short video. It's just talking about expert witnesses. Part 2 is the actual motion where they're outlining their case to Judge Dunley on the accusations that these bad act witnesses are going to provide in the case and how they're going to introduce these people. So, for example, they said, if the defense is cross-examining a witness, then that opens the door for them to bring up further information that witness has to offer. And so it's all a tactical maneuver. There are rules in place to protect defendants from bad act witnesses, and it basically the defense or the prosecution has to prove why they need these bad act witnesses. And at the end of the day, the only reason that the prosecution would need a bad act witness is that they don't have a strong enough case to convict the person on their own. So then they need to bring in these people telling these stories of alleged incidents that are similar to the alleged incidents of the alleged Jane Does in these, or the actual Jane Does, but the alleged victims in the case. So what I am about to share with you, and I'm telling you now, I am not going through reading this whole document because it's even longer than the last one. But this is a memorandum of law in support of the government's motion in Limine to admit certain evidence and preclude other evidence and arguments at trial. And so they basically go over, they talk about the government respectfully submits this memorandum currently scheduled to commence, for the case that's currently scheduled to commence on August 18, 2021. Specifically, the government seeks to admit one, certain text messages of and relating to the individual identified in the indictment as Jane Doe number 5, who we know is Ariel. 2, an electronic note written by Jane Doe number 5 recording statements of the defendant. And 3, newspaper articles written more than 20 years ago. And B, to preclude the introduction of certain arguments and evidence in trial, including evidence of cross-examination and or argument regarding 1, the victim's involvement in other behavior pursuant to federal evidence 412. 2, certain religious practices of a witness. 3, prior psychological histories of certain witnesses. 4, certain actions of the parents of minor victims. Well, we definitely need the parents' actions to be included in whatever y'all about to bring into this case. 5, prior good acts of the defendant. And 6, a certain witness's subsequent employment as an exotic dancer several years after her encounter with the defendant. For the reasons set forth below, the court should grant the government's motion. And then it gives the background where they basically talk about how they were able to get the indictment against him in 2019. And then the argument, evidence and argument regarding behavior of the victims with anyone other than the defendant or other persons at his discretion and or any purported predisposition of the victim is inadmissible. So they basically don't want them to be able to admit that, these people had questionable behavior, that none of them were virgins, that they, were promiscuous, that they were out there slinging it like it was hot, because it probably was hot. And it says, for these reasons described below, the defendant should be precluded from eliciting on cross-examination or otherwise introducing evidence or making arguments as to the sexual behavior of the alleged victims with individuals other than the defendant or others at his discretion, at his direction. So basically what they saying is that they was hoes before they met him, and they were even bigger hoes while they was with him, because they were sleeping with him and his friends and his employees. That's basically what they're saying though. So it says, A, legal standard, Federal Rule of Evidence 412 expressly provides that in a criminal proceeding involving sexual misconduct, evidence offered to prove that a victim engaged in other behavior or evidence offered to prove a victim's predisposition to sex is not admissible except in 3 narrow circumstances. Aims to safeguard the alleged victims against the invasion of privacy, potential embarrassment, and sexual stereotyping that is associated with public disclosure of intimate details. But we already know this stuff because they done put it out there. They done wrote books about it. So people already know. So victims of misconduct to institute and to participate in legal proceedings against alleged offenders. The provision of Rule 412 apply in a civil or criminal proceeding, and then they give all these court cases. So basically what they're saying is that they want to limit R. Kelly's defense to only talking about the sexual relationship between him and these groupies. They don't want, so for example, if the person had 20 sex partners, by the time they met him, they can't bring anybody in to say that, basically that this person was promiscuous. They wanted to seem like the only person that this person slept with was R. Kelly, and that he, is responsible for their behavior, for their, deviancy, for their actions in the bedroom, that he constructed all of that him and only him, and that any prior relationships had nothing to do with what happened when they were with him. So that's basically what they're saying there. And I'm not going to read all these different cases that they're using to support not wanting, they basically bring up a bunch of cases where people weren't allowed, where the defendant wasn't allowed to fully defend themselves. You know what I'm saying. You get what I'm saying. So it says, application is noted above when the defendant intends to assert that a victim's behavior other than with him, or in this case, others at his direction. Rule 412 requires that the defendant file notice 14 days in advance of trial. The defendant has not provided the required notice, and the government respectfully submits that there would be no basis to do so here. Here, any evidence of a alleged victim's behavior with anyone other than the defendant or other persons at the defendant's direction, as well as evidence of any purported predisposition, would be wholly irrelevant to the charges against the defendant. Actually, it wouldn't, because they could have been sleep. So we know, for example, Geronda slept with Bubba, right? But she willfully slept with him. Like, he didn't tell her to sleep with him. You know what I'm saying? Like, these women were sleeping with each other, and he didn't necessarily tell them to sleep with each other. So it's like, how do you determine what he directed them to do and what they willfully did on their own? Okay, and so skip over that. It says, in addition, even assuming arguendo that evidence of a alleged victim's unrelated activity or predisposition is relevant, and then it has in parentheses, it is not, any probative value would be marginal at best and substantially outweighed by the dangers of unfair prejudice, confusion of the issues, misleading the jury, and embarrassing the victim, and it should thus be excluded. But you're going to be misleading the jury and embarrassing the defendant. So, I mean, what's good for the goose? So they basically don't want the defense to be able to bring up their prior history. So accordingly, the court should preclude the defendant from, 1, introducing evidence regarding the victims engaging in acts or contact with anyone other than the defendant or other persons at the defendant direction, or having any type of sexual predisposition, or 2, otherwise referencing such inadmissible evidence during voir dire, opening statements, cross-examination, and closing arguments. 2, the court should preclude the defendant from cross-examining regarding religious beliefs or experiences pursuant to Federal Rule of Evidence 610. The government anticipates that a previous longtime girlfriend and former manager of the defendant, an individual hereinafter referred to as witness number 1, and whose identity is known to the government and the defendant, will testify pursuant to a subpoena and judicial grant of immunity about the events surrounding the bribery charged in Racketeering Act 1 of the indictment, which occurred in or about August 1994. And you guys know that's the Aaliyah related charge. The government respectfully requests that the defendant be precluded from cross-examining witness number 1 about a religious experience described in a book, witness number 1, published in 2011. In the book, witness number 1 detailed various experiences in his life. Now, is this Demetrius Smith drug addicted ass? Okay. As well as experiences connected to his years-long friendship and working relationship with the defendant. Throughout the book, witness number 1 discussed his faith as a Christian, expressed his commitment to God, and wrote about times in his life in which where he felt either further or closer to God based on his own conduct, including with respect to the defendant. In describing one incident involving the defendant approximately 2 or more years after the charged bribery scheme in Racketeering Act 1, witness number 1 discussed having a significant spiritual experience with the defendant. Specifically, witness number 1 wrote that while dining in the restaurant area of an athletic training facility with the defendant after a workout session, witness number 1 was sitting at a separate table acting as a form of security while the defendant sat with female friends. The defendant made eye contact with witness number 1, sat up from his table, and asked witness number 1 to follow him into the men's bathroom. There, the defendant began to cry and stated in a remorseful voice that he, the defendant, felt the Spirit of the Lord on me. They both began to praise God, and then both began speaking in tongues and praise dancing. And when witness number 1 heard another voice coming from the defendant, witness number 1 questioned whether he had heard the voice of the Holy Spirit speaking through Rob, a reference to the defendant, or the devil, during the encounter because the defendant sounded demonic. Speaking in tongues, also known as glossolalia, I guess, is a practice of religion's experience in which people produce utterances, approximately words and speech, usually produced during states of intense religious experience, where speakers and witnesses may interpret the phenomenon as possession by a supernatural entity, conversation with the divine. Okay, witness number 1's religious beliefs and practices, including the religious experience described above, have no bearing on his credibility or any other relevant matter under the circumstances of this case. Indeed, cross-examination on these beliefs in order to impugn witness number 1's credibility is precluded under Rule 610 of the Federal Rules of Evidence. Okay. So they don't want to talk about, is he allowed to talk about witness number 1's drug addiction and how he stole from him over the years? Is he allowed to talk about that? And how his sister slept with Rob when he was underage? Okay, I don't know if he could talk about all that. But anyway. Moreover, the prohibition under Rule 610 prevents cross-examination of not only the religious belief itself, but certain conduct resulting from religious beliefs. Rejecting defendant's attempt to distinguish between cross-examining a witness regarding his religious beliefs and cross-examining him regarding conduct that is significant only because of the witness's religious beliefs, and finding that district court's exclusion of cross-examination on decision by witness of Muslim faith to affirm rather than swear on an oath before testifying was proper under Rule 610. As the Second Circuit has explained, there is no difference between challenging a witness's credibility by cross-examining him regarding his religious beliefs and challenging the witness's credibility by cross-examining him regarding an act that is meaningful only when considered in relation to the firmness of the witness' belief. Moreover, the religious experience described above took place approximately 2 or more years after the events surrounding the bribery scheme and occurred decades before witness number 1's upcoming anticipated test. They say anticipated. They ain't sure Demetrius gonna show up, y'all. Okay, it says, and thus has no bearing on witness number 1's testimony regarding the defendant's relationship with Jane Doe number 1 or the bribery scheme charged in the indictment. It is thus irrelevant to the charges in this case. So I'm not even understanding why they bringing up this unless they plan to introduce the situation that happened in the bathroom at the athletic building, at the athletic facility. But then they don't want, so Demetrius is going to tell that story, and then they don't want the defense to cross-examine him about that and about, are they saying that they can cross-examine him but they can't delve into his religious beliefs? Not sure. So here we got a whole bunch of redacted stuff. It says the defendant should not be permitted to reference prior psychological histories. relevant facts. And so all of this is redacted. And so he's basically talking about these crazy chicks and, their suicide attempts and that type of stuff. We already know that that's what that is. So all of that is redacted, so we can't see it. So then it goes on to number 4, and it says the defendant should be precluded from making legally irrelevant and prejudicial arguments regarding the parents of certain victims. Okay. And so it says certain racketeering acts and substantive counts allege that the defendant coerced these people, including the individuals identified in the indictment as Jane Doe number 1, Jane Doe number 2, and Jane Doe number 5, to engage in activity prior to their being old enough to legally consent. To prove these offenses, the government expects to present evidence showing that Jane Doe number 1, Jane Doe number 4, and Jane Doe number 5, and you guys know that's Aaliyah, Geronda Pace, and Azriel Clary, spent a substantial amount of time with the defendant despite having not completed high school, and that the defendant may try to deflect the blame for his criminal conduct by offering evidence that the parents of Jane Doe 1, Jane Doe 4, and Jane Doe 5 knew or should have known about their daughter's relationships with the defendant. The defendant may further assert that to the extent the parents of Jane Doe number 1, 2, and 5, child, they keep going from Jane Doe number 2 to Jane Doe number 4 and back to Jane Doe number 2, knew or should have known about their respective relationships. The parents thereby consented to such relationships. Well, they obviously did consent to the relationships, even though legally they could not consent to it. But damn it, they need to be up there in court also with some charges for parental neglect and aiding and abetting, if y'all saying that they knew what was going on. So it says, even assuming that there was evidence to support such claims, the evidence would have no legal bearing as to the offenses with which the defendant is charged. Indeed, consent by either the parent or the alleged victims is not a defense to such charges. Accordingly, the defendant should not be permitted to elicit testimony from the government's witnesses, including Jane Doe number 4 and Jane Doe number 5, during cross-examination, introduce evidence or argue that the parents of the women who the defendant coerced to engage in activity were aware of, consented to, or were otherwise responsible for such activity. Such arguments are legally irrelevant and would only serve as a distraction to the jury. Irrelevant evidence is not admissible. Well, y'all get ready to put up a whole bunch of irrelevant evidence. So I guess when the defense filed their motions, I guess they can tell the judge to not allow y'all to put y'all irrelevant evidence up as well. So it says, similarly, the defendant should not be permitted to introduce evidence of any schemes by the parents or the alleged victims to profit or otherwise extort the defendant on account of the defendant's relationship with their daughter. Specifically, Jane Doe number 5 has advised that her parents proposed certain business adventures with the defendant whereby they stood to profit if the defendant agreed to such business ventures, and while she was 17, encouraged her to take photographs of the defendant, which could later be used against the defendant, given in part her status as a minor. As discussed above, the actions of Jane Doe number 5's parent, and you guys know this is the Clarys, have no legal bearing on the defendant's guilt as to the alleged crimes involving her. It has a lot of bearing on it because it would explain why she was in his presence, and then it would also explain why, when she turned 18, she decided to enter into a consensual relationship with him, and why she remained in that consensual relationship for 4 or 5 years, had communication with her parents, blah, 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 blah. So accordingly, the government respectfully submits that the defendant should not be permitted to elicit any testimony or otherwise introduce evidence regarding any of the parents' involvement in business ventures or other means to profit from the defendant. And then this would also go to, well, Dominique isn't one of the Jane Does as far as alleged victims, but she definitely, and then that was the other thing I wanted to point out about the last video that I did. I forgot to mention, it doesn't necessarily state that all these Jane Does that they were introducing, it doesn't state that those people are actually going to testify. And they actually stated that one of the people has flat out refused to testify, say they ain't coming, they don't care what they say. But then it goes on to talk about all these other allegations, but it doesn't say whether or not those people have agreed to testify. So, for example, Dominique, has always maintained that she was not going to be a part of this trial. Now, she may have changed her mind and decided that she will participate. But, just using her as an example of somebody who says that they're done with it, they're moving on with their life, and they don't want to be a part of it. And then I also find it interesting, and maybe it's because she's a part of the Northern District case, why they wouldn't try to introduce Rashana into the case. So they are going to talk about the 2008 trial. So does that open the door for the defense to then say that they want Rashana or the Landfares, her mom, to come through? We know the dad can't come because he passed away. But does it then open the door for them to get them on the stand and get some information that might help the Chicago cases? So anyway, it goes on to number 5. It says that the defendant should be precluded from offering evidence of prior good conduct. So the government moves in limine to preclude the admission of any evidence or argument at trial by the defendant regarding prior good conduct, including but not limited to evidence of the defendant's awards or honors received in connection with his career as an entertainer. Any evidence on these topics is totally irrelevant under Federal Rule of Evidence 401 and should thus be excluded under Federal Rule of Evidence 402. In the alternative, the court should exclude the evidence under Federal Rule of Evidence 403 because such evidence is likely to confuse the issues, mislead the jury, and result in unfair prejudice to the government. But y'all gonna do the same thing, but you all are gonna do everything that you're asking the judge to not let the defense do. So A, it says evidence of the defendant's prior good conduct is irrelevant. Any tendency to make a fact more or less probable than it would be without the evidence. And B, the fact is of consequence in determining the action. Federal Rule of Evidence 402 in turn provides in pertinent part that relevant evidence is admissible unless otherwise provided for by the U.S. Constitution, a federal statute, the Federal Rules of Evidence, or other rules prescribed by the Supreme Court. Rule 402 further provides that irrelevant evidence is not admissible. Evidence of prior good conduct, such as the defendant's awards of honors, involvement in the community, or other charitable works, is totally irrelevant to any of the issues at trial. Any such evidence or argument regarding such topics should be excluded. Evidence of prior good conduct is unduly prejudicial. So basically, they're going to say that, I guess if he talks about his awards and his community service, that the jury will look at him differently, that the prejudice is also unfair if the evidence was designed to elicit a response from the jurors that is not justified by the evidence. So basically, they don't want the jury to relate to Robert Sylvester Kelly. They just want to see him as this cold, callous person who is doing all these ungodly things to these ungodly women who put themselves in ungodly situations. So it says, assuming that any prior good conduct would be relevant, it should be excluded under Rule 403. For example, the admission of any evidence of prior good conduct of the sort described above would present a substantial risk of confusing the jury. The jurors could lose sight of the issues that they are being asked to decide. Whether the defendant committed the essential elements of the charged offenses. In addition, the introduction of such evidence could improperly invite jury nullification. If presented with evidence about the defendant's personal history of musical accolades, there is a significant possibility that the jurors will let sympathetic feelings for the defendant interfere with their duty to apply the law to the facts, which could result in substantial unfair prejudice to the government. Number 6, the court should preclude the defendant from admitting evidence of cross-examining Jane Doe number 8's employment as an exotic dancer. Now, the exotic dancer was, oh my God, her name began with the M. Oh God, I can't think of her name. M-O. Montreal. Oh my God, I can't think of her name right now. But she was one of the people that sued him. And I think she tried to accuse him of getting her pregnant or being the father of her child or something too, and made her have an abortion or something, child. But her name begins with an M. The government also respectfully requests that the court preclude the defendant from cross-examining one of the government's witnesses regarding her employment as an exotic dancer, as the government set forth in its motion regarding evidence of uncharged conduct that it intends to elicit at trial. Eliminate to admit certain uncharged acts. Jane Doe number 8, an individual whose identity is known to the government and the defendant, is expected to testify that she met the defendant on September 1994 when she was 17 after a concert at which he performed. After the concert, she was escorted backstage. Years later, she who is a trained dancer, became employed as an exotic dancer for a period of time. In addition, in connection with her employment as an exotic dancer, she was a plaintiff in a class action lawsuit, sought back pay as a result of claimed labor law violations. Her employment as an exotic dancer and the subsequent lawsuit are not relevant to the facts about which she is expected to testify. So basically, they don't want the defense to raise any questions about the questionable character, about all these questionable characters that they're about to parade up there on that stage, or on that I can't even, child, I lost my train of thought. But anyway, who they're going to bring up there to testify to the witness stand. So in addition, even assuming that evidence regarding her subsequent employment as an exotic dancer of the civil suit, seeking back pay for wages earned as an exotic dancer, were somehow relevant, well, I think it would show that she has a propensity to sue people, because she sued him, and now she done sued the people at the strip club. Now, child, okay. So it says any probative value would be marginal at best and substantially outweighed by the dangers of unfair prejudice. Okay, blah, blah, blah. Indeed, the only reason to cross-examine the witness on this issue would be an attempt to inflame and potentially unfounded bias held by the jurors with respect to employment as an exotic dancer. Unfairness may be found in any form of evidence. Prejudice is also unfair if the evidence was designed to elicit a response from the jurors that is not justified by the evidence. Accordingly, the government respectfully requests that the court preclude the defendant from admitting evidence relating to her prior employment as a stripper or cross-examination of Jane Doe 8 on this topic. So number 7, certain text messages by Ariel and relating to Ariel should be admitted. Oh, so we're going to let the storyteller get up here and be admitted. All right. So at the trial, the government seeks to admit certain text messages as recorded recollections, prior consistent statements, excited utterances, and present sense impressions. First, the government seeks to admit certain text messages written by Jane Doe 5 between April 2015 and December 2015, when Jane Doe 5, well, we know Ariel, was 17 and could not legally consent in Florida or California. Second, the government seeks to admit certain text messages written by Ariel and employees and associates of the defendant about several occasions where she and other women with whom the defendant was living, including the individuals identified in the government's motion to admit uncharged acts as to number 16, 17, and 18. So that's, I'm thinking Jocelyn might be one of these people. And I can't think of that girl, LaTanya. I think I said LaToya in my last video, but I think her name is LaTanya. And who else lived there? And Dominique were subjected, and then it might have been Haley also, Hallie, were subjected to punishment by the defendant, including physical abuse, withholding of food, and isolation. Hold on a second. I lost my space. Hold on, guys. I went too far down. Okay. So, A, the text messages the government seeks to admit are 1, text messages of Jane Doe 5, who's Ariel. The government is in possession of a cellular telephone that she used from the time that she first interacted with the defendant at a concert on April 18, 2015 through June 21st, 2015, when she left her telephone in Florida and began to travel with the defendant full time. In text messages found on the phone, she recounted to her mother various interactions that she had had with the defendant. For example, shortly after she met the defendant and played some of her own music for the defendant, she recounted to her mother in text messages how the defendant was impressed by her musical talent and indicated that he was going to help her make it in the business. 2 of those text messages are below. So the first one says, he, referring to the defendant, liked both. He said the video's nice, for it just be us doing everything. He also liked my writing. Remember, I sung it for him live, so he already knew. With the beat, he could understand it better. He said he likes how it has that radio-ready sound that anyone could relate to. He said it's nice and cute, not too young or grown, but that sound that'll never go out of style. And then in the second one, it says, yeah, that's why he, referring to the defendant, called me laughing my ass off, or LMAO. He said he want to go into the studio. I think he really want to sign me under him, to be honest. Thereafter, the defendant invited Ariel to travel from her home in Florida to visit him in California, where he was then performing. At the defendant's instruction in text messages on April 28, 2015, Ariel contacted one of the defendant's assistants, provided her birthday, showing that she was 17, and requested that the assistant arrange her travel to California. On April 29, 2015, at the defendant's expense, Ariel flew to California to see the defendant. In text messages, Ariel communicated with the defendant's assistant and her mother about the particular hotels where she was staying and the cities to which she traveled. During that first trip to California, Ariel also recounted to her mother some of her interactions with the defendant, including those quoted below. The first one was be talking about rules. The second one, but he got me in sweats. And then in the next one, he ain't like my tights, showing my figure. And then in the fourth one, he just texted me. He said, although he isn't with me, this wasn't a waste of a trip. He said, I should you this time. I guess that's supposed to be showed you this time to try and ease my mind and soak in everything he's been telling me. So when I actually go into this industry, I'll have a mature frame already. And then the next one said, everyone having fun, and Kels said, do not leave that room. I mean, none of this proves anything. Well, first of all, it proved that he did have her out there because she wanted to be a star, and so he was showing her the ropes, which is basically what K. Michelle and what the Johnson lady, the Celine Johnson what they said, and they both say he controls his environment. Like, he can't have them running around crazy and can't have people coming in and out. So those text messages to me just proves that she went with him so that he could show her the industry and what she would have to deal with. So at trial, Ariel will explain that during that first trip, the defendant advised her of certain rules she would need to follow, including his direction that she wear sweats rather than form-fitting clothes, and that she should wait in the room for him. Don't leave the room. So it says the government is also in possession of text messages written by Ariel to two friends identified herein as friend 1 and friend 2. Those text messages span October 15th to January 16th and include messages to friend 1 wherein Ariel, at the age of 17, describes that the defendant ejaculated inside of her and that she believed she was pregnant, that the defendant wanted her to have an abortion because she was 17 and not 18, the age of consent in certain states. Now, don't this sound like a setup, y'all? Like, what 17-year-old traveling with R. Kelly is going to be texting such detailed information to her friend? And so it says that including California, where she and the defendant then were, and she feared having to get an abortion. Jane Doe, or Ariel, also describes in the messages how the defendant reviewed the messages on her telephone and did not want her to speak with her high school friends, including friend number 1. In messages to friend number 2, so if he was reading her text messages, why would she text the friend all that information that they just claimed that she texted? Okay, friend number 2, which messages were removed from an iCloud account used by friend number 2 and are further detailed below. Ariel describes how the defendant had confined her to her room in December of 2015. Jane Doe number 5 later learned that she was not in fact pregnant at this time. Child, we know she wasn't. Number 2, employees' text messages about Ariel and other women. The government obtained forensic images of 2 telephones used by 2 former employees of the defendant, respectively identified herein as employee number 1 and employee number 2. Allowed the government to make forensic images of their phones. A review of the text messages on those telephones showed that the employees exchanged text messages with each other and others describing how, during the time periods relevant to the charges in the indictment, the defendant confined Jane Doe number 5 to a room, withheld food from her, and physically abused her. The text messages also described how the defendant physically abused women other than Ariel. In these text messages, employee number 1 and employee number 2 referred to Ariel as niece or N after the defendant introduced employee number 1 and employee number 2 to Ariel as Ariel's aunties. Certain of these text messages are described below, and the full text messages, along with the government's proposed redactions, are enclosed as Exhibit A. So A, November 4th, 2015, physical abuse of Jane Doe number 5. Text messages between employee number 1 and employee number 2 show that employee number 2 witnessed the defendant physically abusing Jane Doe number 5, Ariel. And you guys, I think that these text messages that they are referring to were text messages that were floating around on Instagram. There's like early on in this case, I believe it was Angelo was releasing what was supposed to be all these text messages between people that work for R. Kelly. And you guys may have seen some of those with Jocelyn, where Jocelyn was begging the assistant to get R. Kelly to call her so that she could come visit. So it was like all these text messages were floating around on Instagram that they are referring to in this indictment. And you can go check Instagram. They might still be out there. So November 5, physical abuse. Text messages between employee number 1 and employee number 2 show that employee number 2 witnessed the defendant physically abusing Ariel. Employee number 2 would testify. consistent with the text messages that she witnessed the defendant arguing with Azriel, and then after the defendant asked her to leave the room, she heard what sounded like the defendant hitting Azriel with his hand. Okay, so she didn't witness this. She heard what she thought was. Like, he could have been clapping his hands. Y'all know how folks be clapping while they talking. So specifically, in a text message on November 4th, 2015, employee number 2 sent a text message to employee number 1. Rob got on niece, referring to Azriel, about lying, and already, just that quick, she has lied again, and then a bunch of question marks. But this time was not just a literature and then a bunch of question marks. I'll tell you, and another employee of the defendant, employee number 3. Later, we're at the studio and I can't talk. Later, so she was saying, I'll tell you guys later, but we're at the studio right now and I can't talk. So later that day, she wrote, I didn't hear the hand, but I heard what was about to take place. So when he asked me to leave, I told him I had to use the restroom. He told me to tell Donnie, another employee, to show me where. So by the time I was back in the area, I heard the after effect, cries, future consequences. So basically, she didn't hear nothing. Or what they consider to be the physical abuse, because she said she walked away. So employee number 1 responded, oh wow, and do you think he used a belt? To which employee number 2 wrote, hand. So B, December 10th, 2015, isolation of Azriel. So text messages between employee number 1 and employee number 2 show that on December 10th, 2015, employee number 2 saw the defendant require Azriel to stay in the back room of the studio at 219 Justine Street in Chicago for a period of time, and that he only permitted her to come out to eat and use the bathroom. Below are some of the text messages where they discuss how Azriel was confined to the back room of the studio. Employee number 1, where is she? Referring to Azriel, what are you? And then employee number 2, she's in the back room, I'm still in the front. I guess she was saying, where are you? Employee number 1, so he's had her in there all day. Has she come out to use the restroom or eat? Employee number 1, where's R? Where's niece? Employee number 2, she came out to go to the restroom and eat. They are still in the room next to the studio. Okay, child. December 27th to December 28th, 2015, confinement of Jane Doe. Text messages between employee number 1 and employee number 2 show that employee number 1 saw that the defendant confined Azriel to a room for more than 24 hours on or about and between December 27, 2015 and December 28, 2015. On or about December 28, 2015 at approximately 7:30 p.m., employee number 1 described to employee number 2 in text messages, niece has been confined to the room since around 6 p.m. and he has, whoever Jane Doe number 16, referring to other girlfriends of the defendant, including Jane Doe number 17, are upstairs, but he's gone home. So why was they dumbasses still up there? Okay, that was me saying about why they dumbasses were still there. If he was gone. Okay. So look. I done confused myself. So it says, let me back up. So it says, they're upstairs. So the other 2 girls were upstairs, but he's gone home. When employee number 2 asked 6 p.m. yesterday, employee number 1 responded, yes, yesterday, actually maybe around 8 p.m. That same day, as referenced above, Jane Doe number 5 herself, Azriel herself, sent a series of text messages to a friend. So she locked in the room, y'all, but she had her phone to text. And she was explaining that the defendant had, in fact, confined her to a room and the reasons for the confinement. These text messages are shown below and were recovered during a search of friend number 2's iCloud account. It says, I just felt to rebel as I did, and then I was like, can I take a shower? Can I take a shower? And he was like, no, you're going to stay in this room until you tell me why you, and then it cuts off. And then it says, first of all, I never had an attitude. You always think someone And then she wrote made, but it should be mad. And then in the next text message, it says, and then I kept calling and texting him over and over. So she was being a little spoiled, whiny brat, and he was sick of her. So he was basically babysitting Ariel for her parents at this time, and she was getting on his nerves. So the government intends to argue that the text messages sent by Jane Doe number 5 conveyed that the defendant confined her to her room without permission to even leave for a shower as punishment because the defendant perceived her to have an attitude and that the confinement was going to continue for as long as the defendant mandated. Well, Jane Doe number 5 should have had her ass in Florida with her family and not being a pain in the behind to a grown ass man who has a career, who's trying to make music, and she disrupting his studio session time. Oops, I didn't unplug my computer again. Okay, so January 2nd, 2016, withholding of food as to Jane Doe number 5. And I hope y'all noticed that a birthday doesn't pass by now, right? So now she's 18 years old as of January 2nd, 2016. So withholding food on text messages between employee number 1 and employee number 2 show that employee number 2 observed that Jane Doe number 5, Ariel, went across almost 3 days without eating, and in context that the defendant was the reason for her not eating. Hold on a second. I hate when this thing skip. It won't scroll, and then when it does scroll, it goes too far. Okay, let me get back up here. Okay. Specifically, on Saturday, January 2nd, 2016, employee number 2 told employee number 1 in a text message, niece has eaten since Thursday. We sat at Red Robin's for hours and he didn't even feed her, shaking my damn head. I just gave her some chips and queso, cold queso, and clarified in a subsequent text message that she meant has not eaten since Thursday. The government intends to argue that the withholding of food on or about January 2nd, 2016 is an example of the control the defendant had over Ariel, and that the control exerted by the defendant extended to dictating what she was permitted to eat. Whatever, because if we sitting up in damn Red Robin, damn it, I'm ordering me a burger and some of them fries, okay? And why she didn't flag down one of them employees? And what was, had the sister left at this point? Because remember, the sister, Clarice, or whatever her name is, had initially went with Ariel to stay with R. Kelly, but then she got sick of the BS and she came home and left her little sister there with that man, and then the parents didn't even bother to go claim their child. So it says, B, January 4th, physical abuse. Text messages between employee number 1 and employee number 2 show that on January 3rd, 2016, the defendant held a birthday party. Well, wait a minute now. Ariel had a birthday on December 30th. He didn't throw her no birthday party, but he threw a party for Jane Doe number 16. And did I say Jane Doe number 16 was Haley? Yeah, I don't know, child. Whose birthday is... Oh, Lord. Who else's birthday is in January? When is, I'm getting these Jane Does confused. So I'm thinking this probably was Hallie that he was throwing a birthday party for, or Dominique. I need to go back and get all these extra Jane Does together. So it says, specifically in the early morning of January 4th, 2016, employee number 2 sent a text message to employee number 1 stating, I'm convinced Rob is going to beat whoever number 17 as soon as possible, but I'll have to tell you later. So do not call me right now, child, because I got to get the tape. Okay, I just added that on, y'all. She didn't say that. So that evening, employee number 2 wrote a text message to employee number 1. Rob talked to me about last night. He talked about the girls dancing, twerking, and touching on each other. He doesn't like that unless he orders it. And he told Jane Doe 16's mother, he was going to get on her and the other girls, and she better not come up those stairs to intervene. It was loud and thumping up there. So, child, remember they say about the mamas cooking in the kitchen? So, that's either Hallie or Dominique, because remember, Michelle Kramer used to be at the house, and then we know Hallie mama used to be hanging around too. So, on May 7th to the 10th, 2015, confinement of Jane Doe. Text messages between employee number 1 and employee number 2 show that employee number 2 observed that the defendant confined Ariel to the defendant's tour bus between May 7th and May 10th. The text messages also reference a prior occasion observed by employee number 2 where the defendant confined another girl, Jane Doe number 16, to the studio for 2 days, specifically on the early morning of Tuesday, May 10, 2015. Employee number 1 and employee number 2 exchanged the following text messages. Now, if I'm the jury and I'm sitting there getting the opportunity to go over this stuff, I'm going to be asking, what the hell was employee number 1 and employee number 2 doing, and why are they not in this indictment as co-defendants of Mr. Kelly? Like, why are all these people getting a free pass for all these stories and text messages and stuff that they're sharing? So it says employee number 1, also in referring to Ariel, is still on the bus since Saturday. He has other girlfriends of the defendant, including who I'm thinking must be Hallie, with him. We're headed to the gym. Then employee number 2, wow, Ian must have done something and is now punished again. Is the bus rolling with y'all? That means Top Gun, referring to the bus driver, has to stay up and with the bus. And then employee number 1 wrote, I don't know, or IDK, we're on here now, but she's referring to Ariel in the back. No, I stayed with her Sunday night from around 9:30 p.m. to 9:30 a.m. She was in the back and it was peaceful. I didn't even hear her move at all. No restroom or nothing. I got much needed sleep. Then whoever number 16 went to the bus for a few hours. We just left the bus. She's still there. Something is strange. Then employee number 2, is she getting food? Referring to Ariel. And then employee number 2 said it was strange for whoever number 16 is to be left at the studio for the 2 days she didn't move around. We'll never know or figure out what the real deal is around that camp if we don't witness it with our own eyes and ears. So obviously y'all don't even know what y'all talking about. Y'all just some gossiping employees. So employee number 1 says 12 hours question mark. I slept at least 9 of the 12. I showered and changed clothes before I went out there. It is inhumane. He's in the back. We just walking in about 20 minutes ago. Okay, now I'm sure that there's more conversation going on because I don't know what we're supposed to take from all this. Because if she was asleep 9 of the 12 hours, then how does she know who did what? So D, May 16 to 17, 2016, confinement of Jane Doe number 5 again. Ariel was getting on R. Kelly nerves. Now, I don't know what he was doing to her, if he was being mean and cruel and inhumane to her, but I do know from reading this here that she was getting on his damn nerves, and she should have put him on and he should have put her on the first thing, smoking back to her parents. So it says text messages show that employee number 1 observed that the defendant confined Ariel to the tour bus on or about May 16, 2016 and May 17. Well, should she be headed to her graduation around those dates? Specifically, on the morning of May 16, employee number 1 wrote to employee number 2, fucking tour bus within. I got to the studio about 30 minutes ago, so I relieved another employee. They don't say who the employee is, but they'll be referred to as employee number 4 from the tour bus so she could leave. That evening, I'm thinking this is Hallie, the other girlfriend of the defendant, sent a text message to employee number 1 saying, Mr. Kelly said to come to the bus to pick Azriel up on May 17, 2016 at approximately 9:55 p.m. Employee number 1 wrote to another employee of the defendant, employee number 4. Okay, so employee number 1 just in everybody's business. She just gossiping and just sharing everything, right? So it says, when she, referring to Azriel, gets to Florida, so remember this is her graduation, she needs to run and never look back. She should be living the fun life of an 18-year-old high school senior, and I agree. She was on the bus again. I relieved whoever employee number 4 is on the bus when I got here yesterday morning around 7 a.m. and a girlfriend of the defendant relieved me around 10 a.m. Then he had me to pick her up from the bus around 7 p.m. and she's been in the back room. She looked rough, eyes puffy, and etc. She was left there last night. Okay, so when they on the bus, where everybody else at? Like, was he touring? Like, was the bus touring from city to city doing some concerts? I need to look up his concert schedule for 2016. Because why was they all on this bus? It sounds to me like they were traveling, right? Does that not how it sounds to you all? And remember, he was on the tour bus when he took Azriel to her graduation. So it seemed like they were en route to Florida for the graduation. So of course they was on the damn bus for a long time. Anyway, so physical abuse by the defendant. In a text message on January 16, 2017, employee number 2 sent a text message to the defendant explaining, Jane Doe number 18 woke me up crying saying you took her phone, saw pictures and messages to other guys and jumped on her. She showed me her face where she said you slapped her, and she pulled down her pants showing me bruises on her butt saying you spanked her. Lord Jesus. Now I think this is Jocelyn. Or was it Dominique that was talking to the other girl? I cannot keep up with all this foolishness that was going on. Okay, so we know 16, 17, 18 is Holly, Dominique, and Jocelyn. We just don't know in what order. So F, witness number 2's text with the defendant about Azriel. Okay, so the government also anticipates that another witness identified herein as witness number 2 will testify at trial regarding her relationship with the defendant. Among other things, the government anticipates that witness number 2 will testify regarding events in which she saw a girl who looked like a child in June and July of 2015 with the defendant. During these instances in which witness number 2 saw the defendant with the girl who witness number 2 learned the following year was Azriel, was sitting on the defendant's lap, and on one of those occasions, Jane Doe number 5, Azriel, was playing with the defendant's ear and the defendant was rubbing her buttocks. Azriel was under the age of 18 during June and July of 2015. During the course of their relationship, witness number 2 maintained contact with the defendant, including via text message. In some of the text messages exchanged between the defendant and witness number 2, the defendant tells witness number 2 where he is and where she should meet him while she was visiting the defendant. What? During the course of their relationship, witness number 2 maintained contact with the defendant, okay, including via text message. In some of the text messages exchanged between the defendant and witness number 2, the defendant tells witness number 2 where he is and where she should meet him while she was visiting the defendant, including on the dates in which she saw the girl she later came to realize was Azriel. And so once again, I'm thinking this is the LaTanya chick. So in addition to the text messages related to when witness number 2 saw Azriel, the defendant also texted witness number 2 about having rules that he expected his girlfriends to follow. On March 14, 2016, during the one text exchange with witness number 2, the defendant wrote that he did not think witness number 2 was, quote, strong enough to be in his world, end quote. And when she asked why, the defendant responded, quote, because my world is huge and it comes with many rules. Right, because you got to contain and control them heifers. So B, applicable law. So 1, relevance. The text messages that the government seeks to admit are highly probative of the defendant's coercion of Ariel to travel to California. Now, child, we ain't seen no coercion in nothing you just wrote about her going to California for the purpose of activity, despite that Ariel was not old enough to consent to such activity, and despite that the defendant did not obtain Ariel's consent to expose her to the transmitted disease he knew he had. Significantly, many of the text messages were sent prior to Ariel's 18th birthday at the end of 2015, and the nature of those messages would strongly corroborate Ariel's testimony that the defendant engaged in activity with her on the first occasion they met in Florida after the April 1815 concert. Okay, girl. And virtually every day after that. Not every day, girl, including during trips to California. Every day, Ariel. Are you sure? Because I think Hallie was his main woman at that point. So I don't think he was sleeping with you every day, girl. So the text messages are also highly probative of the defendant's commission of the forced labor offense, and it is tied to the racketeering enterprise. Specifically, the messages make clear that various forms of coercion used by the defendant to obtain labor and services from what labor did Ariel perform, and his employees and associates rose in the coercion. These were some gossiping employees. This wasn't no coercion because they was going to run their mouth regardless of what was going on. So these forms of coercion, including isolation and withholding of food, the punishment, including the confinement and physical abuse, when the defendant decided that Ariel had violated one of the defendant's rules, the defendant's physical abuse of other women, often in front of Ariel, is also probative of the racketeering and forced labor offensive. So guys, it sounds to me that they are basing a large part of their case on these stories Ariel got to tell, and that they need all these other witnesses to corroborate and try and back up what Ariel is saying, when Ariel is basically repeating a lot of stuff that she heard from the other people and that she read in these books and that she saw in Surviving R. Kelly. So in addition, the text messages, I'm sorry, I lost my place again. In addition, the text messages exchanged between Jane Doe number 5 and friend number 1, and between the defendant and witness number 2 during the instances when she saw Ariel are relevant because they are probative of the defendant's relationship with Ariel while she was under the age of 18, and corroborate witness number 2's recollection of her sightings of Ariel in the company of the defendant in a manner consistent with an intimate relationship. So sitting on somebody's lap meant you were in an intimate relationship. So in addition, the defendant's text messages to witness number 2 advising her that his world comes with many rules and she was not strong enough or probative of the racketeering and forced labor offenses, particularly the expectations that the defendant had for individuals with whom he had relationships, and the fact that he believed the rules were onerous. Oh Lord, onerous. I'm so tired, y'all. It's almost 2:00 in the morning. Onerous in nature, given his statement that witness number 2 could not handle them. I'm sure that many of successful professional people have told somebody that you ain't about this life and I need you to go head on. So I don't think that is against the law. So number 2, the text messages are not barred by the hearsay rules. Under the federal rules of evidence, hearsay is a statement that one, the declarant does not make while testifying at the current trial or hearing, and 2, a party offers in evidence to prove the truth of the matter asserted in the statement. Federal Rule of Evidence 801C, written assertions. And so they basically going on trying to justify why they can enter these text messages and create their own narrative based on those text messages to try and prove their case. And so then they start talking about other cases, and I'm not going to read that. And then excited utterances. An excited utterance is a statement relating to a startling event or condition made while the declarant was under the stress of excitement, and it caused the rationale for this hearsay exception is that the excitement of the event limits the declarant's capacity to fabricate a statement and thereby offers some guarantee of its reliability. And then they quote some cases where it says that the excited utterance exception is based on the psychological impact of the event itself and permits admission of a broader range of hearsay statements, those that relate to the event. And then they, of course, they're quoting cases that they're using to try and support why they need to enter this stuff into evidence. And then B, well, did they ever say what the excited information? Several factors may be considered in determining whether a speaker was under the stress of excitement, including the nature of the event, the time that lapsed between the startling event and the statement, the physical and psychological distance of the speaker from the startling event, and the appearance of demeanor of the speaker. So I guess they're basically trying to justify what the gossipers were saying in their text messages, and that they were, I guess, excited, or either the girl who saw her sitting on his lap, and demise that they were in an intimate relationship because she was sitting on his lap. And that's probably some of those pictures. Remember the pictures that started surfacing where it looks like they're in a dressing room or something? Y'all remember that picture? It's in one of my prior videos. A present sense impression is any statement describing or explaining an event or condition made while or immediately after the declarant perceived it. So these statements are considered to be trustworthy because the contemporaneity, I know I'm pronouncing that wrong, but I'm so tired, y'all, of the event and its description limits the possibility for intentional deception or failure of memory. So basically how I'm reading this to you guys, and then I'm throwing out my take on what they're talking about, that would be present sense impression, because I didn't read this document and then came back with my commentary. I'm giving you my commentary as I'm reading the document and giving you my immediate response to what it is that I'm reading. And so then they give case law, based on why they support this. And then C, recorded recollections. A record concerning a matter about which a witness once had knowledge, but now has insufficient recollection to enable the witness to testify fully and accurately, shown to have been made or adopted by the witness when the matter was fresh in the witness memory, and to reflect that knowledge, is also a recognized exception to the rule about hearsay for a statement. Then they quote some case law. And so basically they're saying, like, when she was sending text messages to her friends about whatever was going on, even though she can't recall what exactly happened or led up to her writing that text message to her friends, the fact that she wrote the text message immediately after, during, or after what had taken place lends to its truthfulness of what she was feeling at that time. So D, declarant, witness, prior consistent statement. Let's see, where a declarant testifies and is subject to cross-examination, the declarant witness's prior statement is not considered hearsay when it is consistent with the declarant's testimony and is offered one to rebut an express or implied charge that the declarant recently fabricated it or acted from a recent improper influence or motive in testifying, or to rehabilitate the declarant's credibility as a witness when attacked on another ground. The advisory committee amended this rule in 2014 to expand the reasons for which prior consistent statements may be offered. Before the amendment, substantive use of prior consistent statements that were probative, I think I've been saying probative throughout this document, probative, to rehabilitate the declarant's credibility were only admissible to rebuke charges of recent fabrications, improper influence, or improper motive. The intent of the amendment is to extend substantive effect. So basically, an example of what they're talking about here is they're trying to say that Ariel's current behavior, remember when she did the Snapchat when she was cussing out her dad, talking about, how much she loved R. Kelly, and then when her and Jocelyn were on the Gayle King show defending him, they're going to tell the jury, dismiss all of that, what they said after the fact, but only believe what she said in 2015 and 2016. Don't believe what she said in 2019. So that would be an example of what they're talking about there. Then they go on and say that prior consistent statement is being offered to rebut an express or implied charge against the witness of recent fabrication of improper influence or motive, that the prior consistent statement was made prior to the time that the supposed motive to falsify arose. While there is no established test to determine the admissibility of prior consistent statements under Rule 801D 1B2, the Second Circuit has upheld district court findings that prior consistent statements are admissible non-hearsay under subsection 2 when introduced to rebut defendants' attacks on declarants' credibility and memory. Okay, child. So they were quoting a case there. So then goes on, Rule 801D1 applies to a witness who is subject to cross-examination and does not restrict admissibility to statements of one who has already been cross-examined. And so when they're talking about examined and cross-examined, they're basically telling you, like, this is their strategy, is that they're going to try and prevent the defense from asking particular questions during cross-examination that would lead to the credibility of whether the person was telling the truth then or whether they were telling the truth now. Okay, analysis. The government anticipates that Ariel, employee number 1 and employee number 2 and employee number 4 and witness number 2 will all testify as witnesses for the government and therefore will be subject to cross-examination by the defendant. While the government anticipates that the witnesses would generally recall much of the conduct described in the text messages above, they do not recall each episode and the timing and details of each episode, and will testify that their text messages about the conduct were accurate at the time they sent them. To the extent that the witness recalls the content of a particular episode, the text messages as to that particular episode should be admitted as prior consistent statements to rehabilitate the witness. To the extent that the witness does not recall the content of a particular episode, the text messages as to that episode should be admitted as prior recorded recollections. Moreover, many other text messages above should be admitted as excited utterances of present sense impressions as the messages were written either while or shortly after the witness perceived the particular events described in the text message. Okay, so once again, we're talking about employees that are gossiping about their employer and someone in the employer's custody, because remember at this point he was supposed to have been teaching her the business. And so if you are a gossiper, of course you are excited to go and replay some gossip, okay? And most people that gossip and are excited about gossiping, they usually add on to what actually happened or what they actually witnessed. And so you can't say verbatim that what they were saying was the truth, because people have the ability to ad lib and add on. So just how earlier I would read what was written here, and then I would add like 4 or 5 words on to what was written here, but then I come back and say to y'all, okay, now that was just me saying that, that was because I was excited, okay, as I was reading that, at the audacity of what they were writing, and then I just added a little more on to it. So basically that's what could be happening with these employees as they're sending these text messages. Okay, so then it goes on. And says, and to the extent that the messages or partial messages do not qualify under one of those exceptions, the government submits that they will be admitted not for their truth, but as background information to give context to other texts that are admissible under these exceptions. Then they quote a case, United States versus Pedroza. When statements by an out-of-court declarant are admitted as background, they are properly so admitted not as proof of the truth of the matters asserted, but rather to show the circumstances surrounding the events. Providing explanation for such matters as the understanding or intent with which certain acts were performed. Accordingly, there is no hearsay bar to their admission. And then number 8, the court should admit an electronic note written by Ariel. And so it says the government seeks to admit an electronic note saved on a cellular telephone seized from the defendant's home upon the defendant's arrest in July 2019, at which time he was living with Ariel. The note appears to have been drafted on August 30th, 2018, when Ariel was 20 years old and after she had been living with the defendant for more than 2 years. In the note, Ariel wrote, "Do not be goofy, extra, or act young when I told something in private or around others. Do not play games when on the phone with daddy. Just say I love you before I hang up. Continue to do what I always do around others when I am alone with daddy. Bless you when daddy belches. Trust daddy and do whatever he says whenever he says, with no rebuttal, disrespect, or rebellion. Remember how I acted in the beginning, bubbly and like a child, pure and with no negative intentions. And remember to stay true to who I am, humble, happy, innocent, and beautiful to daddy, reminding him of his mother and the child. Tell daddy everything so he will not have to wonder and figure out what is going on with me." So once again, I assert that these had to be the dumbest damn people in the world, because in the time period that they are stating that this happened, that she texted this or wrote this in her phone, the surviving R. Kelly was already finished. They were getting ready to wrap things up. So why would she be writing stuff like this in her phone if it wasn't intentional? Because at this point, nobody should be writing anything in the phone. Nobody should be texting anything, because you already know that these people are after him, that they're filming this documentary where they're trying to expose him and come at him and harm him. So it seems like she wrote that intentionally just in case she decided, or her daddy decided, that she needed to flip sooner than she did. So the government intends to argue that in context, Ariel wrote the note to recount instructions given by the defendant as to how she should act around him. But y'all don't know what, okay, anyway. Among the instructions was one to do whatever the defendant says, whenever he says, with no rebuttal, disrespect, or rebellion. The note is thus highly probative of the defendant's commission of the alleged forced labor offense as to Ariel, as part of which the defendant used physical force, threats of physical force, physical restraint, and threats of physical restraint, and other means of psychological, I lost my down arrow, psychological something, child. Coercion to Ariel to engage in activity, not just with the defendant, but also with many other, okay, we already, women and men. So they're repeating all of that. Ariel will testify that the defendant provided the instructions set forth in the note. Ariel's testimony as to the defendant's statements are, of course, admissible as a statement of a party opponent, and the government does not intend to offer the contents of the note itself for the truth, but instead as a recording of the statements made by the defendant. Okay, so did she, okay, I'm confused now. Did she write this note, or was she recording him saying these things? Okay, August 30th, 2018, when Ariel was 20, and after she had been living with the defendant for more than 20 years, in the note, she wrote that. So we don't know if he said that to her or not. Okay, so let's go down here. The government does not intend to offer contents of the note itself, okay, but as a recording of statements that she claimed he made. Okay, so number 9 is this? Would this be number? No, that wouldn't be number 9. X. Okay. And I got my Roman numerals all messed up, y'all. Okay, the court should admit certain newspaper articles as ancient documents. The government seeks to admit certain newspaper articles as ancient documents pursuant to federal rule of evidence. Specifically, the government seeks to admit newspaper articles from 1994 showing the defendant performed in Macon, Georgia on August 30th, 1994, Albany, Georgia on August 31st, 1994, and Miami, Florida on September 2nd. Relevant to evidence at trial, the government anticipates that witness number 1 will testify that one summer in the 1990s at a concert where the defendant was performing, the defendant advised him that Jane Doe number 1, who was then 15, was pregnant, and that the defendant intended to marry her. Okay, so this is Demetrius and his nonsense. Following the ceremony, the defendant and witness number 1 returned to the defendant's concert tour. Records from Cook County, Illinois show that on August 30th, 1994, an application was granted for the defendant and Jane Doe number 1 to be married. The certificate indicates that they were married on August 31st. The address listed on the certificate for the ceremony was 6501 North Manheim Road, Rosemont, Illinois, the address of a Sheraton hotel located near O'Hare Airport in Chicago. The newspaper articles the government seeks to admit reflect that the defendant performed at a venue in Macon, Georgia on Tuesday, August 30th to a very small crowd, and on Wednesday, August 31st at a venue in Albany, Georgia, and that witness number 1 was in fact the defendant's tour manager on August 31st. And all of this is in 1994. In light of the defendant's performances, the government intends to argue that the defendant and witness number 1 flew to Chicago on or about the evening of August 29th, obtained the fraudulent identification document for Jane Doe number 1, who we know as Aaliyah, and the marriage certificate on August 30th, were married on August 30th, but recorded it as a day after the certificate was issued on August 31st. At the Sheraton Hotel, and flew to Georgia in time to perform at the venue in Macon that night. Child, that was a whole lot of flying back and forth for somebody that don't like to fly. Okay, so the government also anticipates that Jane Doe number 8 would testify that when she was 17, going into her senior year, not legally able to consent, the defendant penetrated her with his wee-wee. The woman will explain that she met the defendant at a concert promoted. So this is the, I can't think of that woman's name, Martinez. Which Jane Doe number 1 was scheduled to perform with the defendant and others, but that Jane Doe number 1 did not ultimately perform. The woman will further testify that the defendant penetrated her after she went backstage to get an autograph with the defendant. The newspaper articles that the government seeks to admit show that the defendant was scheduled to perform in Miami on September 2nd. I might have been at that concert, the Budfest tour. I might have went to the one in Orlando. That the concert was sponsored by Budweiser, and that Jane Doe number 1 had been cut from the tour in light of her being just 15 because it was sponsored by, an alcoholic beverage. Legal analysis. The articles the government seeks to admit are relevant. It has the tendency to make a fact more or less probable than it would be without the evidence. So basically they're saying that they're entering these newspaper articles as a way of verifying where he was on certain dates at certain times. So moreover, the articles do not constitute inadmissible hearsay. Statements in a document that was prepared before January 1st, 1998 and whose authenticity is established, provides that newspaper articles are self-authenticating, right? Because they have the date and the time and blah, blah, blah. And then it goes, conclusion, for the foregoing reasons, the court should grant the government's motions in their entirety. The government also requests that the court permit the government to file both a sealed and redacted public version of this motion. The redacted version will redact certain content from the publicly filed version of this motion that details medical and other private matters of certain witnesses. Privacy interests of a third party may be compelling. And then once again, as I stated on the last video, these are requests that the prosecution... I done unplugged my dang computer again. Sorry about that. Basically, these are requests that the prosecution is making to the judge as far as evidence. The judge will look over this. The defense will respond to this and give their argument as to why these things shouldn't be allowed. And the judge will then rule on whether or not they are admissible or not. Now, if the judge allows all of this stuff into evidence, then y'all know, we already know she, got an issue with R. Kelly. But if she allows everything, that's a problem, because judges typically don't allow everything into evidence. And so it would be interesting to see the defense's response to all of this. And I am so looking forward to reading it. Y'all know I am. But let's continue on, because they have some exhibits in this document. And so basically, November 4th, text messages, which I've already... Oh no, here's some more text messages. So employee number 2 on April 11th. All of this took place on April 11th that I'm getting ready to read to y'all. Employee number 2, Rob got on niece about lying, and already just that quick she has lied again. Okay, so these are the text messages I've already read to you guys earlier. They have them listed, and these were seeds from employee number 1's telephone. And then they say excerpt where otherwise noted. The text messages were exchanged between employee number 1 and employee number 2. The government proposed redactions are denoted by the text that is struck through. So let me see. Okay, I didn't see nothing that was struck through. Unless where they got these question marks, maybe that's where they're redacting stuff. But I thought that was pretty much. But this time was not just the literature. I'll tell you later. Okay, so we already read that. Okay, December 10th, 2015. Between employee number 1 and employee number 2, where they claim she was held, I think, in the room. Then December 28th, we talked about these already. Now, they called themselves redacting, but all they did was drew a damn line through the stuff. So employee number 1 said, okay, but I will need it back because I owe Melanie dollars for picking up the gift cards for niece and Jane Doe number 16. So you owe me $40 on those because they are $40 each. I gave R back his change, $110 from the $500 he gave me for his gift. So that's supposed to be redacted. Okay, I don't think I read these. It says Niece has been confined to the room since around 6 p.m. and he has, okay, so I did read that V and D are upstairs, but he's gone home. So who is V and D? Whose name began with the V? Valencia? No. Valencia was the lady that bailed him out. Okay, anyway. So some of these we had read, but then like this one was redacted, but I just read it to you about the gift card. So January 1st, 2016. This is between employee number 1 and employee number 2. Employee number 1, what is she doing? Are you cool with not getting out? Employee number 2, laying on the back seat after playing in his pants. Yep, I'm sleepy. It's only the guys. So I don't know who she was talking about. Number 2, do you have Deborah's number? Employee number 2, do you have Deborah's number? Employee number 1, so what happened? Employee number 2, she asked him over the phone. Employee number 1, did she tell him why? What did he say? Employee number 1 wrote G. Employee number 2, she was asleep with her head covered and Van called for my charger and barely cracked the petition. Okay, so V and D in the earlier text is somebody named Van and somebody named Deborah. Okay, so then employee number 1, and what did she say? Employee number 1, partition. Employee number 2, and almost 5 minutes later she told me, next time do not let the partition down without telling her. And I guess they're talking about a partition on the bus. And then employee number 2 wrote, I told her she was asleep with her head covered and the crack was so tight I could barely get the cord through. So I guess she was trying to hand somebody a cord. And then employee number 1 said, and what did you say? And employee number 2, she said, I don't make the rules. I told her, watch her tone with me and next time say please and thank you. And I guess they put the employee number 2's name was there in that text. Employee number 1, what did you say to that? And what did Deborah say? Who do make the rules, you or her? And then employee 2 wrote, Deborah said she hopes she doesn't start mess. And then Rob makes the rules. And then employee number 1, is she still off the sprinter? What are you going to tell him? What did Deborah think about her tone? Employee number 2, yes, the truth, not sure. Employee number 1, are you all stopped or driving? And then she texts again, are you all stopped or driving? And then employee number 2 said that they were stopped. He still has her off the sprinter. And then employee number 1, why are you all still in DTW? What is DTW, y'all? I know DFW. DTW. Anyway, I thought you all were rolling last night. Where is niece? And then employee number 2 said he's in the hotel, I'm sure with a female right here. We chatted. I apologized to her and told her it's all about respect. So based on these text messages, R. Kelly wasn't really thinking about Azriel because he spent a whole lot of time while she was on the bus or in the other room with other females that were more important to him, that he was more interested in. And so then it goes on to say employee number 2, niece has eaten since Thursday, which we already read that, and I think she comes back and says she meant hasn't eaten, and when she talk about the cold queso. Then she says has or has not, and then employee number 2 says has not, and then employee number 1 says that's horrible. Didn't she eat the food from the show's dressing room? So maybe he thought she had some food, and that's why he wasn't trying to get her no food. So then on January 4th, 2016, some more text messages from employee number 1. It says, employee number 2, I'm convinced Rob is going to beat Jane Doe number 17, which must be Dominique, as soon as possible, but I'll have to tell you later, so do not call me right now. And I already read these where she told her to call her later that night. Okay, so I've decided Jane Doe number 16 is Hallie. Jane Doe number 17 is Dominique. And Jane Doe number 18 is Jocelyn. Okay, so then employee number 2 wrote, okay, I'm just going to put the name in. Dominique was talking to me last night about how non-supportive he is when it comes to her career. She's fed up. Then Hallie's dyke cousin pulled D and started stepping with her, and then pulled Dominique, I'm assuming, and started stepping with her, and it got a little too freaky to the point Dominique's mom had to tell her niece to stop because that was beyond stepping. You could see fury written all over R's face. Then once the dancing stopped, the girl sat down in the bar chair and D was standing between her legs. V came over, and V is oh my God, V was in the car. You guys have to go back to some of this older stuff. V was in the car with the stylist, whose name is also Cash, but not the Cash that was involved with Don Russell. Another Cash who was his stylist. There was somebody named V in that car where they were talking and said that the feds wanted to talk, and that she was going to tell about the incident where he hit Holly at the club or something when she was talking to the guy or something like that. But I can't remember what V's full name is. And so it says, had to tell her niece to stop. You can see the fury in his face. The girl sat down in the bar chair and D was standing between her legs. V came over and playfully pulled D away, and then D disappeared upstairs alone. I could tell that V was ear hustling with D, was talking to me by the bar, but I had absolutely nothing to say. I changed the subject. And then in that part, I don't know if they're talking about Dominique or they're talking about the Deborah chick that they mentioned earlier. And then employee number 1 said, damn, that's so crazy if they are fighting. And then employee number 1 said, what made her feel comfortable enough to talk to you about it? What is her career? How old is the niece? So Haley's family knows R. I think V is jealous of Dominique, I guess. Although I like V, I don't trust her. She's the one who snitched on D when we were in New York. D may eventually leave. Where's niece, Deborah, Haley, and Haley's mom? D may have done all of that to get him angry. So I'm thinking D is actually Dominique, because she actually names the Deborah person in the text. Okay, still don't see nothing criminal here. And then employee number 2 replied, D was overly friendly and talkative with me last night. She's 24 years, a novel writer. The work she showed me writing book cover is phenomenal. She said he pretends to be interested in helping her, but shows no interest, and that he never wants them talking to anyone or going anywhere. She said she's tired of his ways. She's a beautiful young lady. No, they didn't know him. Her BBF was here too. Her cousin is somewhere between 25 and 30. Niece is still in the room. Deborah is sitting right here up front. Haley is upstairs with Rob, VD, VD, J, Lord Jesus, Jocelyn. Okay, so the V girl, Dominique, V, Dominique, Jocelyn have been upstairs all night. I'm getting ready to take a shoe. I'll reply back later. Okay, then employee number 1, who's BFF? Haley? Where's Haley's mom? Has the fighting stopped? How long has D been with him? Then employee 2 replies, just remember your cues because I'm deleting your text. Do not call, text me. I'm out with Rob and a girlfriend, but take care of the shoes and invoice. Okay, I'll call you later. And then employee number 1, I'm working on invoice now. What does R call us? MW Consulting, right? Employee number 1 might have been a snitch, y'all. She might have been a plant because she asked a whole lot of damn questions trying to get a whole lot of damn information. So employee number 2 wrote yes. Employee number 1, okay, I sent you the invoices for December and January. Employee number 2, you can't get the total price. What amount do you suggest? Is your account safe? And then employee number 1, no, it's not. Check on depositing the money on your child support card. In order to get the total, you have to check out, but I will try. Give me a few. I'm driving. Where are you all? My account is $244 overdraft. I'm calling Wells Fargo to see if I can get it. Child, that number... employee number 1 ghetto as hell. Now, how is her bank account overdrawn? She talking about putting money on the child support card. She had too much going on. R. Kelly was just hiring anybody. So employee number 2 replied, okay, just let me know. I do not have my card. Diamond keeps her own card now. I can't do anything until tomorrow. I'm at the movies with Rob, a girlfriend, but Haley and her mom is on the way now. And then employee number 1, we went to, what are you all seeing? Employee number 2, Danish Girl is very good. Employee number 1, okay, I may go to see it Thursday or Friday. Employee number 2 is very good. Employee number 2, we need to get Rob something for his birthday. Employee number 2 and Haley. And then employee number 1, okay, balls for R. Employee number 2, okay, just let me know. I do not have my card. Diamond keeps her own card now. I'm sure I'll end up going to the bank tomorrow to make a deposit. Let's Google personalized pool balls. I saw a website. And then employee number 1 said, okay. And employee number 1, I may not have time. My call time is 11 a.m., but if I'm out before 5, then possibly. And then employee number 2 said, okay. Then employee number 2 went on to say, Rob talked to me about last night. He does not like Haley's best friend. He got on her today about the tweaking, I think she meant twerking, for a piece of cake. He called her gay cousin a dude and said he told her females only, and about the dude flirting with V and D. I only saw the cousin flirting with D. He was also upset about Haley sitting on her gay cousin's lap because he was molested by family, so he feels that could lead to them messing around. He talked about the girls dancing, tweaking, which I think she means twerking, and touching on each other or in each other. He doesn't like that unless he orders it, and he told Haley's mom he was going to get on Haley and the other girls, and she better not come up those stairs to intervene. It was loud and thumping up there. He said he's going to teach us how to pick up on vibes because people would try to be sneaky with us, and he don't like that. So just be careful and mindful. Rob just don't know. I'm far removed from being a fool. Not only do I recognize and know psychology reverse, I am the damn psychologist. So that was employee number 2. So then on May 10th, 2016, employee number 1 wrote, he left a female sitting in the little foyer of the studio and we're gone. Unless he texts and tells her to leave, she will be there at least 3 hours, shaking my damn head. Also, N is still, referring to Ariel, is still on the bus. He has Jocelyn and V with him and another female. Good night, Roland. And then she has a lot of question marks. And then she says, he left the female sitting in the little foyer of the studio and we're gone. Unless he texts. Okay, so she texts the same thing twice, like 7 minutes apart. V and a girlfriend with him. We're headed to the gym, rolling, and then a bunch of question marks. And then a friend put, okay, I was dozing. Don't know who that friend is. Employee number 2 replied, wow, N must have done something and is now punished again. Is the bus rolling with y'all? That means Top Gun has to stay up and with the bus. Employee number 1, when I get off at 11:30 a.m., can you stay a couple of hours past so I can run to Angelica's for a quick shampoo? It literally takes her 1.5 hours to do my hair, and she's 4 blocks walking distance from the studio, so at least until 3 p.m. Also, don't forget I have the General Union meeting on Monday, 5/16 from 1 to 3 p.m. So please relieve me around 10:30 to 11 o'clock Monday morning. Also, let's work on the June calendar today, making sure you're off the week of the BET Awards, and I'm off the 7/1 through the 5th for Essence Fest. And I was at I went to that Essence Fest as well. Okay, so employee number 1, I don't know, we're on here now, but she's in the back. No, I stayed with her Sunday night from around 9:30 to 9:30 a.m. and I already covered this. She was in the back and it was peaceful. I didn't even hear her move at all. No restroom or nothing. I got much needed sleep. Then Jocelyn went to the bus for a few hours. We just left the bus. She's still there. Something is strange. That's fine, but hurry. I'm ready to go. Okay. And then employee number 2 said no restroom for 12 dang hours. Oh yeah, she's in trouble. He had her using bottles, and there's a sink in that bedroom. So employee number 1, she hasn't been off since the show. That's inhumane. Wow. Damn, I pray she's alive. Employee number 3 said he spanked her not long ago, maybe when she was behind on her work when it was time to go to St. Louis. Where is he? I'm sure a girlfriend is gone, right? So I guess she was referring, well, now this was 2016, so she shouldn't have been doing no homework for school. So I don't know what homework she had done. Employee number 2, is she getting food? It was strange for Jocelyn to be left at the studio for the 2 days she didn't move around. We'll never know or figure out what the real deal is around that camp if we don't witness it with our own eyes and ears. And see, and y'all just having full-blown conversations. And then employee number 1 said 12 hours. I slept at least 9 of the 12. I showered and changed clothes before I went out there using bottles when? No, she was not, unless she got off when they went to the park, because I got to the park after them and I didn't get out or call him. I took a nap. She may have said or done something pertaining to Joy. It is inhumane. He's in the back. We just walking in about 20 minutes ago. A girlfriend is here. Employee number 3 said Jocelyn was on punishment for being too in his business and looking at the other girls too much. I'm going to sleep until 10. Oh, child. Then May 16, 2016. And it says employee number 1, did he even see her? Employee number 2, he does still have company. So just in case I don't get my money before I leave, these are the airline receipts. I believe his company is leaving now, so if she does, I'll get it before I leave. If she got gone, I'm leaving to go to the W to shower and dress. Hopefully she leaves so I can save Uber money to the W. And then employee 1 said, where's Jocelyn and the others? I'm turning my phone off until I get there. I only have 15% battery. Employee number 2, 3 upstairs, 1 on the bus. Employee 1, the driver is not here. Employee number 2, so did you get the code from employee number 4? Employee number 1, I have the code already. How long has she been out here? Fucking tour bus with niece. I got to the studio about 30 minutes ago, so I relieved employee number 4 from the tour bus so she could leave. The worst part is that she's lying right here on the couch instead of bedroom. She's lying right here on the couch. I wish she was in the bedroom. And then Jane Doe number 16, which is Holly, texted number 1 and said, Mr. Kelly said to come to the bus to pick Ariel up. Employee number 1 replied to Haley, okay, I'm here. And then Haley said, okay. And then employee number 1 said the driver just got off, coast clear. And then Haley said, okay. And then employee number 1 to Haley said, I texted and called Mr. Kelly, but no answer. Should the back door be open? I'm just checking if I should close it before I get in the shower. Don't want to lock one of you out. And then she said, no, that was employee number 1 talking to Haley. And then Haley said, 1 second. And then employee number 1 said, okay. And then Haley said, Mr. Kelly said to lock it. And then employee number 1 to employee number 3. Nothing at all. We got here from B-Ball around 5 a.m. this morning and has not been anywhere today. Luckily, employee number 3, oh, same old, same old. Those girls got to be insane in the true meaning of the word to be tolerant of that life. And then employee number 1 did the question marks and said something is really strange about the treatment and behavior of the little one. The punishment is real. And then employee number 3 said, yeah, she got to be losing her mind seriously. How is he treating her now? And then is she still on punishment? And then employee 1 replied, when she gets to Florida, she needs to run and never look back. She should be living the fun life of an 18-year-old high school senior. She was on the bus again. I relieved employee number 4 on the bus when I got here yesterday morning around 7 a.m. And Haley relieved me around 10 a.m. Then he had me to pick up her from the bus around 7 p.m. And she's been in the back room. She looked rough, eyes puffy, and etc. She was left here last night. Jocelyn, her mom, V, and D all went to the gym last night. D acted like she was happy to be in the mix. She's been on punishment forever. And then employee number 3 said, wow, somebody told something on her like J or V. Employee number 1 said, I'm sure, probably J. So what they saying, Jocelyn is a little snitch. Okay, they tell every goddamn thing. It's ridiculous. They are the fastest texting bitches I ever met. But that girl needs to go home. And that's in all caps. And then employee number 3 said, I agree. Maybe she will. Unless she thinks this is it. And it don't get no better. Employee number 1, yep. Employee number 3, you okay. Then somebody from a 773 texted, said, we are rolling to B-Ball. N is out tonight. V made her exchange seats with her on the Sprinter. V sat beside R. N at door. And remember when they're saying N, they're referring to Ariel. I can tell that N was taken aback by the demand. They are all vying for that number 1 spot. Yes, hell they were. He has a very nice Christmas song with piano that he is going to get RG to play on. RG. Who's a piano player? Initials RG. We are rolling to B-Ball. And is out tonight. Happy, and there's a bunch of question marks. V made her exchange seats with her on the Sprinter. Then somebody with another area code 404 is basically telling the same thing that's the area code 773 told. And it says V made her exchange seats with her on the Sprinter. V sat beside R. N at door. I can tell that N was taken aback by the demand. They are all vying. Okay, so maybe she forwarded that. I'm not sure. I don't know, because 2 different people wrote the same thing. So July 16, 2017, text messages seized from employee number 2's phone. From somebody, area code 312, it says, employee number 4 admitted that she agreed with some things you and Bug have said about me that she shouldn't have because she knows it was wrong. Employee number 4 also admitted that she was jealous of my boldness from how I dealt with you personal business to driving the Sprinter and was intimidated by my knowledge and how easy I made handling your business and driving the Sprinter look. Also, before Jocelyn got with you, she wasn't wearing name brand clothes and shoes. Asked Jocelyn who she traveled with to Miami, slept with, and he bought her those Giuseppe heels. Since she's been with you, Rocco, Monica's son's father, asked Jocelyn about her questioning me about the other girls and asking me if it was true that you mess around with guys, because that's what one of your friends told her and her mother, and I told her not to believe whoever was telling her, and her mother lies about you, and that she should tell you. And she told me she was in communication with Jocelyn's boyfriend through social media, and she told me that Haley left because she wouldn't sleep with her one night when you called Haley to the Trump to fix the TV. And Rob, I'm not the only one Jocelyn has talked to. I just chose not to entertain the mess and to just mind my business. The last I heard from whoever Jane Doe number 18, I'm saying it's Jocelyn, it might not be Jocelyn, is when I blocked her. I'm thinking, okay, so maybe 18 is the LaToya girl or the LaTanya girl. Anyway, I blocked her and deleted her number out of was when she texted to tell me she bought me lotions and gels for Christmas from you. She can't stand employee number 4, and she finally met the girls. Rob, I honestly didn't care about your business with those girls for some time now. The reason I'm sharing this with you now, okay, so whoever this person is, they're talking to R. Kelly. I told you I'd never tell you what someone had to say about you because I didn't want to see you hurt, and I hate and I am not used to mess or drama. I haven't even told anyone I'm no longer working with you to avoid questions and lies, but I could no longer stand by and watch and hear about my name being misused. I care way too much about my character and integrity. Okay, so this person is the cash girl, I think. And I still have brotherly love and respect for you. And then she went on to say, Jane Doe 18 has tried on several occasions to talk to me about you, and I've shut her off because I didn't want to get mixed up in childish drama. Employee number 4 and Jane Doe number 18 told me how you'd say I was the devil and mean. Employee number 4 said she knew better because you would say the same things about her and Shell to a girlfriend, but she would just play along with you. She and Jane Doe number 18 said you think I gave one of the girls' parents the addresses to the big house and guest house. I'd never do something like that. Employee number 4 said you went off on Deborah and left me in Atlanta because you were told Deborah and I had been sitting around the hotel bar talking about you. I've never talked about you to Deborah, and she's never talked about you to me. Deborah is a true friend to you. When employee number 4 told me I never said anything because I didn't trust her to engage in conversations about it. And number 2, I didn't care, exclamation point, exclamation point, exclamation point. But I already knew because I was in the studio VIP section napping one day. And as soon as you and Bug left the studio, Jane Doe number 18 woke me up crying, saying you took her phone, saw pictures and messages to other guys, and jumped on her. She showed me her face where she said you slapped her, and she pulled down her pants, showing me bruises on her butt, saying you spanked her. She then said she wanted to leave you, but was going to stay until you got her boobs done. Alrighty then, that sounds like a conscious decision to me, not somebody that was being held captive. She then said she wanted to leave you, but was going to stay until she got the boobs done. I told her she was wrong for staying for that reason, and I told Jane Doe 18 if she was going to stay with you, I never wanted to know her business where you were concerned because I didn't want my name in any drama. This girl could have picked up the phone and said all this. She done wrote a whole damn book. So anyway, that's where it ends with the text messages. I still think Jane Doe number 18 is Jocelyn, but it's weird that they say Jocelyn's, like they'll say the people's name in certain places and then use Jane Doe in other places. So maybe Jane Doe number 18 is actually the girl that he told that she wasn't about that life and she had to go. And I swear that girl name is Latanya or Latoya. And I believe she is the girl in Precedence where you see Azrael and her sitting in the kitchen or something and they're talking and it seems really made up and contrived. And so guys, this I'm still at the 2-hour mark. But anyway, that's the end of part 3. I gave you my commentary as I was reading this. So you have to decide for yourself. Go ahead, leave your comments below, rate the video, and subscribe to the channel if you haven't done so already. And until the next time, I shall talk to you guys later. Bye-bye.